Logan Paul may have just painted himself into a little bit of a corner in his defamation case against Coffeezilla. And by that I mean he just made an argument to the court that might end up unintentionally helping the other side. It has to do with discovery that Paul is trying to get from Don Holland, the class action representative in the CryptoZoo scam lawsuit, and at the same time, Coffeezilla's ongoing effort to get the defamation case removed from San Antonio to Austin so that both cases can be managed by the same judge. If Paul's lawyers are hoping for success, it's going to take some pretty major mental gymnastics to get there. And the way I see it, it might not go too smoothly. Let's get into it. Okay, so to begin, as always, if you're new to this whole saga, there is a link in the description below to a playlist of videos to get you all caught up. But otherwise, let's jump into what's happening here. Logan Paul recently filed a motion to compel discovery from Don Holland. You'll notice that Holland is not a party to the defamation case against Coffeezilla. Rather, he's the class representative for the CryptoZoo scam class action lawsuit. And Paul filed this motion because he wants the court to compel discovery from Holland, ostensibly to be used in the defamation lawsuit. Now, right now, it looks like there are 3 requests that Paul made that are in dispute here. Those are requests 1, 3, and 5. Request number 1 asks for all non-privileged documents and communications concerning CryptoZoo, Logan Paul, and or Logan Paul's involvement with CryptoZoo and or the promotion of the CryptoZoo cryptocurrency, tokens, or NFTs. Request number 3 asks for all non-privileged documents and communications relating to purchases or sales of CryptoZoo related cryptocurrency, tokens, or NFTs, including all potential purchases or sales considered by you, as in Don Holland. And finally, request number 5 asks for all non-privileged documents and communications relating to Don Holland's purchases of cryptocurrency and or cryptocurrency related products other than CryptoZoo related cryptocurrency, tokens, or NFTs. Now, I will say that looking at these requests, they need to be tailored better in order for this motion to be granted. For one thing, when you read them, there's no time limit for how far back Holland needs to go in order to comply with the request. And while, yes, CryptoZoo only existed going back a few years, it seems, the way these requests are written makes it sound like Holland needs to give all communications he has talking about Logan Paul related to any subject at any point in time. I mean, for example, if Holland has text messages from years ago talking trash about Paul for being an idiot who got himself banished from the entire country of Japan, technically that would fit into request number 1 with the way that it's written. And that really would have nothing to do with either of these 2 lawsuits that we're talking about here. Anyway, Holland has also now filed an opposition to the motion to compel. And in his opposition, Holland basically said, no way, Paul's requests are overbroad and unduly burdensome, and here's why. And interestingly, one of the main arguments that Holland makes several times in this filing is he says Paul fails to explain why these documents are somehow relevant not to the class action case, but to Coffeezilla's defamation case. And this is important because if Paul is trying to get evidence out of Holland, it has to be relevant to Coffeezilla's case, not necessarily the class action case. And that's because he's requesting it through the defamation case's discovery process. Even though there's another case going on at the same time that's kind of similar, if you're gonna request it through one case, it has to be at the very least relevant to that case. Otherwise, Paul is most definitely engaging in an improper fishing expedition and abusing the legal process to do it. And another reason for that is because he also knows full well that the way to get discovery for the class action case is through discovery there. But there's currently a discovery stay over there. This means that none of the parties are allowed to demand evidence from one another until other issues in the class action case get resolved first. So Paul needs to show that he's not just trying to backdoor his way into evidence he's not allowed to demand yet. And to do that, he needs to show that it's relevant to this case. Now, personally, I can actually see how most, if not all of this, is in fact relevant to the defamation case. But I don't blame Holland, or Coffeezilla for that matter, for trying to push back to make Paul make the argument himself. And that's because it helps Coffeezilla out to make the words come out of Paul's mouth to the judge here. I'll explain that in just a second, but first I have to thank this video sponsor. This video is sponsored by Privacy. Privacy is a virtual card product and consumer protection-focused brand that helps you safeguard your financial life. Privacy helps you create virtual card numbers for online purchases for a variety of uses. These can be merchant-locked cards that are intended to be only used at a specific place, or category-locked cards that are specific for certain types of purchases like dentists, pharmacies, groceries, or entertainment. Or they can be things like single-use cards that basically burn the card after you use it once. And they have a plan that is free to use with no transaction fees for domestic purchases. Personally, there are two things that I like about Privacy. For one, there's the way these cards can help budget. As an example, you can set certain spending limits on a card. So if prices go up on a particular subscription that you have, you can get flagged by the card and decide whether or not you want to keep that subscription. Or maybe you're like me and you find yourself spending way too much money because you signed up for some kind of an introductory offer on a product, didn't end up using it all that much, and then got hit with an annual subscription because you forgot to cancel it. This happens to me more often than I want to admit. But Privacy can help with that, and I love it. But of course, one of the best things about Privacy is the fact that you can make purchases online without having to give up your credit card number to the vendor. Maybe you want to buy something online, but you don't trust their ability to keep your data safe. By using a Privacy virtual card, you can eliminate that concern entirely. And importantly, according to Privacy, they never sell customer data. Their revenue comes from the interchange itself. So if you want a little bit more peace of mind with your online transactions and get a $5 sign-up bonus for your first purchase through Privacy, go to privacy.com/Legalbytes by following the link in the description below. And thanks again to Privacy for sponsoring this video. Okay, back to the video. Now, I was just explaining that it's helpful to Coffeezilla to make Paul be the one to explain to the judge that the discovery he's seeking from Holland is relevant to the defamation case. The reason for that is because of the motion to transfer venue, which Coffeezilla filed a long time ago now. If you've been following this case with us, you might remember this motion. This is the same one that revealed those scummy text messages Paul sent to his friends where he was talking about wanting to punish Coffeezilla with a lawsuit. You know, to send a message that the world shouldn't screw with petty billionaire Logan Paul. Anyway, in the motion, Coffeezilla is basically arguing for a number of reasons that his defamation case should be moved from San Antonio to Austin so that it can be litigated in the same place as the CryptoZoo scam class action case. One of those reasons is, as I just referenced, that Paul brought this case in part to seek revenge on Coffeezilla for outing Paul, and that Paul basically is just doing this to ruin Coffeezilla's life. But another reason is because Coffeezilla says that Logan Paul is abusing the legal system by trying to get around limitations set on the class action case by doing things in this case. As a prime example, Coffeezilla talks about how the class action case has been under a discovery stay for a while. And so, according to Coffeezilla, one of Logan Paul's reasons for filing the defamation lawsuit was to get around that discovery stay and get evidence from the class action plaintiffs, but through Coffeezilla's case. And so Coffeezilla says this defamation case should be moved to the same venue as the class action case so that the same judge can keep eyes on both of them. Now, at the same time, Coffeezilla also argues that the case should be transferred to Austin because there's a lot of overlap between these two cases. He doesn't yet make the argument that the two cases should be consolidated, meaning that they would be merged into one lawsuit. But he does make the case that they should be both managed by the same judge in order to limit litigation expenses for everyone, including the court. Now, for his part, Paul has responded to these arguments to say, no, there's not enough overlap. These are two separate cases that should be litigated and tried separately, and so on and so forth. But really, Coffeezilla has a good point here, and it has to do with the elements of defamation. Let's take a step back for a moment to remember that in order for Logan Paul to win his defamation lawsuit against Coffeezilla, he has to prove every single element of defamation. And one of those elements is proving that the statement that Coffeezilla made about Paul was a false statement of fact. And the statements at issue here were all tied to Coffeezilla calling Paul a scammer. So that means that in the defamation case, Paul has to explicitly prove Coffeezilla's statement, i.e., that Paul is a scammer, is actually false. And on the other hand, Coffeezilla, as part of his defense, is going to want to show the jury that his statements are in fact true. In other words, Coffeezilla will want to show the jury that Paul did in fact scam the CryptoZoo investors. So, Did Paul scam the CryptoZoo investors or not? This is a crucial question for the defamation case because Paul needs to convince the jury that he didn't scam them. It's a material element of the defamation claim that he's trying to prove here. And if he doesn't meet that element, he doesn't win the lawsuit. And this is why often in these defamation cases, you'll find that it starts to feel a little bit like a trial within a trial. So then with all of that in mind, what does that mean for Coffeezilla's motion to transfer venue? Well, as I just said, there's this sort of trial within a trial situation of defamation, and that basically is asking, was CryptoZoo a scam, and did Logan Paul specifically scam these guys? And that means that there's some significant overlap between these two cases. And more particularly, you could say that the entirety of the class action case actually fits within the defamation case. And honestly, to me, that says not only should these two cases be litigated in the same venue, but the defamation case should probably be put on hold until a jury hears the class action case. Then, once the jury in the class action case makes a decision, that decision also can be used in the defamation case to kind of streamline things in the defamation case itself. Now, to be clear, I have no idea what the judge will actually decide on this issue, but looking at what I think should happen, personally, I think venue should be transferred. And this all rests on a concept called issue preclusion, which is designed specifically for circumstances, well, like this. There are 4 basic elements of issue preclusion. First, the former judgment has to be valid and final. You can definitely get a valid and final judgment with an all-out trial verdict. Second, it has to be the case where in both actions the same issue is being brought. Third, the issue has to be essential to the judgment. And finally, the issue has to have been actually litigated. Now, looking at this CryptoZoo situation with both of these lawsuits needing to answer the question whether Logan Paul scammed the CryptoZoo investors, to me personally, this looks like exactly the kind of situation that issue preclusion is supposed to fit into. Otherwise, you potentially have 2 different juries deciding the same case, which was put on 2 different times with the same evidence, the same witness testimony, etc., etc. As far as judicial economy is concerned, it's potentially a major waste of public resources. So let's take stock of this whole thing for a moment then. Coffeezilla wants to convince the judge that there's tons of overlap between the defamation case and the class action case. And personally, I do think that there is a lot of overlap. But on the other hand, Paul wants to convince the judge that there's not enough overlap to move the case to Austin to be linked up with the class action case. But now, Paul just filed this motion to compel discovery against Don Holland, where he's also trying to get the judge to force non-party Don Holland to cough up a bunch of discovery responses. And here's where we reiterate that one of Don Holland's main arguments in opposition to the motion to compel is that the information Paul seeks from him isn't relevant to the defamation case, only to the class action case. So now, in response to Holland's opposition, Paul is being forced to explain to the judge why the information he's trying to get from Holland actually is relevant to the defamation case. And let me be clear here. I do think that a good portion of what Paul is trying to get actually is likely very relevant to this case. In my opinion, Paul is probably entitled to most of this stuff once he tailors these requests properly with things like limits for how far back in time these documents need to go. But the thing is, Paul is going to need to make this argument to the very same judge who still has yet to make a decision on the motion to transfer venue. And so this puts this issue of overlap between these 2 cases front and center at a time when the judge is probably thinking a bit about this issue already. And so if I'm Paul's lawyer right now, I'm probably asking myself, how can I make the case with a straight face, no less, that this information from the class action representative is relevant to the defamation case, but at the same time that there's really no overlap between these cases? It's silly mental gymnastics, in my opinion. And honestly, I don't envy Paul's lawyers in having to figure out that routine. So at the end of the day, it seems like Paul really has painted himself into a corner here between these 2 issues. And it seems to me that by being so aggressive to get discovery from Don Holland, the class action representative, Paul is only making Coffeezilla's case for why these 2 cases should be litigated under the same roof. But those are my thoughts. What do you think? Do you think there's a lot of overlap between these two cases? Or do you think Logan Paul has good reason for wanting these cases to be litigated separately? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next video.